मॉर्निंग पंकज, आवाज आ रही है मेरी?
जी मैडम, आ रही है आपकी आवाज़। जी।
हेलो।
हम्म।
हेलो।
सर नमस्ते सर, आवाज आ रही है सर?
आ रही है तो आप ज्वाइन नहीं कर पाए क्या? क्यों अंजना?
सर
गुड मॉर्निंग।
मॉर्निंग सर।
गुड मॉर्निंग कपूर साहब, कैसे हैं?
बस सर ठीक हो सर। कुछ कनेक्शन प्रॉब्लम आ रहा था मेरे पास से। जी सर। सो
थोड़ी का वो भेजी थी ऑनलाइन। इट्स ओके।
Rashmi, are you starting the program or you have started already? रश्मि,
सर प्लीज स्टार्ट करिए सर। यस
नहीं आपने, अच्छा चलिए अभी अब जाके कनेक्शन हो पाया सभी का?
यस सर।
अच्छा ठीक। सर सबसे पहले मैं सब आपका लाइक
मॉर्निंग कपूर साहब, कैसे हैं?
गुड मॉर्निंग एंड गुड मॉर्निंग टू
कनेक्शन
Vajpai and all our participants today. Sir, this is the
ऑनलाइन। इट्स ओके।
class of DSP probationers of 42nd batch of DSP. ये अंजना बहुत ज्यादा डिस्टरबेंस आ रही है।
सर प्लीज स्टार्ट करिए सर। यस
डिस्टरबेंस बहुत है नेटवर्क में।
प्रॉब्ली माइक्रोफोन सभी टर्न ऑफ कर लें अपने।
हाँ माइक्रोफोन टर्न ऑफ करें सब। अंजना आप देख रही हैं क्या?
यस सर।
अंजना
सर
हाँ देखिए इतना ज्यादा बजिंग क्यों है?
सर मैं चेक करवाती हूँ।
जी sir, good morning sir. We welcome you on behalf of Madhya Pradesh Police Academy for accepting our offer to inaugurate the International Human Rights Day lecture series today, sir. It's a very important day today, the 10th of December, when we have the International Human Rights Day. You have spent a whole lifetime in mainstreaming rights and accountability, civil liberties into law and law enforcement. Uh, this is a great privilege for us at the Academy to welcome you, sir, on this particular occasion. We are also very fortunate that we, through your good offices, we had a MOU with the National Law University, and every year our trainees go to the National Law University and understand the intricacies of law enforcement through the nationally and internationally renowned faculty which you have, sir. We are very proud to have you with us today, sir. So thank you very much for that. Uh, uh, Today, it is very important for our trainees to know that Sir is a criminologist as well as a law and a police reform expert. सर ने बहुत लंबा समय पुलिस रिफॉर्म्स में गुजारा है and he has served in number of positions. Rashmi will be taking care of the introduction which she'll just now deliver about sir. I will introduce sir and the series today in context of our deep connection which Academy has with National Law University. Sir, this is the 42nd batch of DSPs, and they will also be looking forward to visit the NLU in the coming year if the COVID protocols allow, and have their 10 days stay there as earlier batches had. So this is their first interface with you, sir. And victim justice is a very important subject. एंड मैं सभी ट्रेनिंग्स को ये बताना चाहूंगा कि सर के ही इंस्पिरेशन से विक्टिमोलॉजी का जो इंक्लूजन है वो डीएसपी सिलेबस में हुआ है। और सर मैं आपको ये बताना चाहूंगा कि अभी जो एनपीए ने एक ट्रेनिंग नीड एनालिसिस की एक एडवाइजरी बोर्ड बनाया था जिसमें मुझे बुलाया गया था, तो उसमें सर इसी आपके ही इंस्पिरेशन से विक्टिम जस्टिस को उसमें भी एक इम्पॉर्टेंट एनपीए के आईपीएस ट्रेनिंग में भी विक्टिम जस्टिस को और विक्टिमोलॉजी को एक इम्पॉर्टेंट सब्जेक्ट के रूप में इंक्लूड करवाया गया है. So along with human rights. So victim justice का human rights से क्या इंटरफेस है, इसके संबंध में आज सर से हम सुनेंगे. So before sir we start, first of all I again thank you, and then I'll request Rashmi to read sir's brief introduction. Rashmi Pandey.
Good morning. I'm privileged to introduce Dr. G.S.Vajpai. He is the author, administrator. He serves as Professor of Criminology and Criminal Justice, Chairperson at K.L. Arora Chair in Criminal Law at National Law University, Delhi, and also as the Chairperson at the Center for Criminology and Victimology. He is also the Registrar, National Law University, Delhi. He was serving from 2007 to 2011 as Professor Chairperson at the Center for Criminal Justice Administration, National Law Institute, University, Bhopal. He also had positions at the Indian Institute of Public Administration in 1989, Bureau of Police Research and Development, 1989 to 95, Punjab Police Academy, and Department of Criminology and Forensic Science, University of Sagar, and Doctoral Study 2004, ESCOM Fellow at the Department of Criminology, Leicester University, UK. Thank you, sir, and we welcome you again.
We now request you to start your lecture.
Yes,
sir.
sir. Uh, Thank you, Dr. Vineet Kapoorji. Good morning to all, and good morning to Mrs. Rashmi Pandey for giving me this opportunity to address this group of DSPs at the MP Police Academy on this day. In the beginning, I extend my greetings on the day of International Day of Human Rights to all of you. This day assumes a lot of importance for police because these days the human rights have become a very important interface with the criminal justice system and especially with police. Today, I would just keep my talk limited to the rights of the victim because rights of the victims are gaining very significant importance as far as the functioning of police is concerned. And you will realize that this is one aspect which has long been ignored in the process of criminal justice system. And today, as a police officer, you have a sort of important responsibility to understand that what are the important legal rights that the victims have got as a matter of human right or as a matter of legal rights in the process of criminal justice system. You know why I say that this is important for two reasons. One, our criminal justice system is not primarily oriented to the victims of crime. That is the first thing that you need to remember. The biggest example of this particular statement is the fact that the term victim came to the criminal laws in this country in the year 2008 under Section 2WA of CRPC. This I am saying just to emphasize the point that the recognition, the legal recognition of the victim could take place in this country only in the year 2008. Before that, the term victim was not there in the laws of this country. What does it mean? It is not simply the absence of this expression, term victim. It is basically the significant evidence of our approach to the victims of crime. So, in other words, victim was a missing factor in the criminal justice process for a long, long time. And as you as a police officer would know that if you read all of our laws, IPC, CRPC, you will find the system provides a lot of rights and advantages to the offender or to the accused. But similar rights have not been provided to the victims of crime, and therefore there is an imbalance in the criminal justice system. So today, when we are talking about the rights of the victim, today is a human right, so we need to talk about the rights. What does it mean to talk about the victims of the rights of victim? It is important from the very fact that the original idea of creating the system of criminal justice system must have been to provide relief to the victims of crime by policing, by prosecution, by court. You will find, except being a complainant in crime, the victim. Hello, can you hear me? Okay.
Yes, sir. You are audible. Yes, sir. You are audible, sir.
Okay, great. So I'm saying, except being witness or except being a complainant, the victim does not have a very, solid legal position in terms of influencing the course of justice or the course of the functioning of police. That is my first argument. Now, what happened after 2008? After 2008, certain changes have been introduced in the law, or certain new discoveries of the existing laws have been made in a manner so that the victim's position becomes a lot more prominent. And talking about the rights is a very important thing. The aggrieved person, he is the complainant, he has suffered the brunt of crime, he needs support, he needs all kinds of services which the system is duty bound to provide. But entire discussion you will see revolves around the accused: bail, arrest, probation, parole, aftercare, rehabilitation, compounding, legal aid. All these things you will see they are surrounding to the accused or the offender. And therefore, today I'll discuss 7 important rights that the victims now have. But we need to understand those things in a matter of right. These are already the part of our laws, but probably we are not very clearly recognizing them. I'm saying our laws are very, very mysterious, because if you interpret them in favor of the victim, it is possible. If you want to use against the victim, probably it is also, or if you do not want to do anything, that is also possible. So let's try to find out from this discussion that what exactly I am trying to convey to you through this. As I said, there are very, very important 7 rights I'll be talking to you during this small 30 minutes talk, so that you are clear and you are specific. And these rights are not hypothetical rights, are not imaginary rights. I'll try to take these rights from the laws. But however, these rights have not been mentioned in the manner that I am discussing. So, like for instance, if I say the first right is right to fair deal from criminal justice agencies, that is the first right the victim has. Right to fair deal. Fair deal means a sensitive approach, a concerned response, a positive response from criminal justice agencies. Now, what is the source of this right? Because you are a police officer, you need to work within the framework of law. Anything which is not provided in the law, you may not probably reconcile with that. My insistence is that let us understand, Kapoor Sahab was talking about victimology. Victimology needs to be read within the framework of the Constitution. I'll show you, if I'm saying right to fair deal from criminal justice agencies, where does it flow from? It flows from the Constitution of India. The first and the foremost and the fundamental law of this land is the Constitution of India. And if you see the part 3 of Constitution, that is the fundamental rights. So whatever fundamental rights are available to all the citizens of the countries, obviously those rights are also available to the victims of crime. If you start looking at from the lenses of fundamental rights, you will find the victims have several entitlements which he or she is supposed to possess. Now, second important source is the directive principles of state policy, part 4 of the Constitution, because this talks about the socio-economic justice. And therefore, if you see further, the Article 38 or if 39A, 39A is equal justice and free legal aid to all the citizens. You can look at in your district or in your place wherever you are working, you talk to lawyers or judges, largely the meaning of legal aid in this country is attributed to the to helping the offender. But this 39A, that is the free legal aid, is equally applicable to the victims of crime. Don't you think the victim also needs the legal aid or quality legal support? And 51A, very interesting. 51A casts a fundamental duty on every citizen. You know, what is it? To have compassion for living creatures and to develop humanism. Now, if you want to draw from your constitution, you have every reason to help the victims of crime. Now, this is very important. Nobody reads this 51A. I am not reading it from any popular magazine. I am reading from the Constitution of India. What does it mean when I say that to have compassion for living creatures? Living creatures में human भी है, animals भी है. So we are supposed to have that compassion. Compassion means we need to be concerned about the sufferings and victimization of people, and also to develop a humanism. Humanism is the biggest ideology that the Constitution propagates. And we also say this is the basis of victimology. Victimology doesn't come from the heaven. Victimology is rooted in the Constitution of this country. And as I said, based on all this, we have introduced 2WA, which is now a broader definition of victims of crime. You as a police officer must always remember that you now have a legal definition of victims of crime. So right to fair deal from criminal justice agency is not simply a theoretical idea, it is a practical wisdom. So in all your actions, that fairness, that fair deal to victims of crime is something which is possible. I'm at the National Law University, and I always say, for everything, there will not be any law, nor you should expect all the time to have a law to be able to help a person. Please, are you understanding what I'm trying to say? It is very much within the framework of your duties, and whatever is provided, we work in the framework of rule of law. Nothing stops you to help and support the people who come as a complainant to the police station or to any place where you serve. And generally, I talk to police officers, and this is where it is written that the police should help the victims of crime. I said it is nowhere also written that you should not help. Where it is written. So I'm saying if you want to, as I say, law is a matter of everything cannot be written. Everything cannot be reduced into the writings of the law. Then second is very important, because these rights I'm inferring from the law. Please remember, these are not written. I'm inferring from various laws. Second is, which is very important. And before I move, I also say, since I have talked about the Constitution of India, I also wish to say that let us understand this beautiful Constitution. Our preamble itself says, all these fundamental. Article 14, Article 21, Article 38, Article 39. These are the basis for a state to prevent crime and to own the responsibility towards the victims of crime. We may not have a separate act dealing with the rights of victim, yet there are obvious statutory provisions recognizing the sacrosanct rights for the victims of crime. That is what I am trying to say. And internationally speaking, you all know the United Nations Declaration on Basic Principle for Victims has also talked about 4 important rights. I think you can very well remember these 4 because I'm sharing something to you that this UN Declaration of 1985 is a major source of reforming the laws in various countries. It talks about 4 very important rights to the victims of crime. Access to justice and fair treatment, that is the first. This is very important because victims' access to the system is generally hampered and prohibited. And therefore, this particular right becomes very, very important. Second is the restitution and compensation means, and fourth is assistance. So by way of these rights, we find that but as I am saying that in our laws, we have enough provisions to, help the crime victim. And therefore, I am just mentioning a couple of them to you. Now, next is the right to mobilize. Right to mobilize criminal justice system by lodging FIR. Basically, FIR for us looks a very mechanical thing, but I am telling you, FIR is basically the gateway of criminal justice system. And I have just talked about access to justice. That is the first point of access. The door of criminal justice system is knocked by a complainant with intention to file a complaint. And so that is the first point of access. I need not to say you must be reading all the places. This very access is hampered and prohibited by a variety of reasons and practices that unfortunately dog the police departments these days. Though it is gradually becoming very difficult to deny the registration of FIR by the police because now we have brought a variety of system. What I am saying is that in the era in which you are about to serve the police department, this is going to be very, very challenging. I think last week you must have seen that the Supreme Court has come out with a judgment that every police station will now mandatorily have the CCTV camera installed. CCTV camera installed. The funding will be given by the state. What is the idea of CCTV? And there is another thing Bombay High Court said, because generally the police officer will say that my CCTV camera was not working. That is very easy. They are saying it is the duty of the police officer to ensure that the CCTV cameras are always working. I am saying it is becoming very difficult now. Therefore, if you are aware of the best practices and the best way to work, probably because there are lots of cases of denial of registration of FIR. I am saying the victim is one person who has got this right to mobilize the criminal justice system. If there is no complaint, the system doesn't mobilize. So a complaint becomes the sole basis of mobilizing. So under section 154, when a person comes to the police station, generally he is the aggrieved person. He comes for the police station because the victim has special needs. Victims are mentally and physically challenged. They may require care. They may require special attention. And we have now several other protocols, which as a matter of rights now become available to the victims of crime. Like for instance, the protective in-camera proceedings in the court. The procedural law now mandates that the court shall take appropriate measures to ensure that a child victim is not confronted by the accused. I'm saying these are the rights after the registration of report that the victim will have. The protection against the indecent and scandalous questioning under cross-examination. Voluntary causing grievous hurt by use of acid. These are the new offenses. Medical expenses of the treatment of victim to be factored while deciding the just and reasonable fine to be imposed. These are the rights that the law has provided to the victims of crime. And in addition to that, the compensation and other, assistance and support is also available. I suppose you are aware of the interim compensation provision under Section 357A, where the police officer is supposed to help the victim to to forward the FIR to the District Legal Service Authority so that the victim could get the interim compensation. Interim compensation is a right of the victim. We are here to discuss the rights of the victim. But this right cannot be facilitated unless the police officers become functional. So your activism will help the victim to get their rights and get their dues. The third right that I am mentioning you is right and status during investigation of a criminal case. That is most important for the police officer. See, investigation is a sole domain of the police, executive function. In fact, if you ask me, the one most important thing that rests with the police is the investigation. Investigation means, the entire process, right from registration of FIR under 154 up to 173, the submission of final report. Now, you will be surprised that during this entire process, the role of victim does not seem to figure at all. But as I said in the beginning, if it doesn't figure there, it also does not mean that you cannot be fair to the victims of crime. These days, investigation is expected to be fair. Fair investigation. What is fair investigation? The investigation which is fair to the parties. Now several things are important from the viewpoint of investigation, because I've said third right is right and status, both. Status means the dignity. Sometimes the victim is treated as at the same footing that of offender. Victim is not a culprit. Victim is a aggrieved person. He should not be treated at par with accused or the offender. He is in the police station to seek the assistance from the police. And therefore, he has a right to dignity. Right to dignity is very important. It is the part of Article 21 of the Constitution of India. Right to life includes right to dignity. And this dignity is very, very important as far as the victim is concerned. Because you would all agree, after experiencing the crime, the dignity of the victim gets automatically lowered because he is the sufferer. He has been, assaulted upon. He is before a police. Lot of people are visiting him. Lot of people are talking about him or her in the society. So his dignity has already been assaulted. But therefore, if you see 164A, now medical examination has been added as a very important right, especially in rape cases. But we all know that the insensitivity with which sometimes the medical examination is carried out by the doctors along with police, that becomes a very, very serious matter of concern. However, this right is very, very important. So 164A, when medical examination of victim, it includes the right to status and dignity. Victim should not be subjected to any further victimization. I'm using a word which you should remember: secondary victimization. What is secondary victimization? Primary victimization is because of crime. Secondary victimization is because of insensitivity shown by police, prosecutors, courts, and other officials, doctors. So victims should not be subjected to a secondary victimization. Primary victimization, he or she has already suffered. But you can very well save him or her from this discomfort, this unconcerned approach, and therefore the victim has a right to fair deal, as I have said. And then 173 1A provides that the investigation in relation to rape of a child especially may be completed within 3 months from the date of information received. So now 3 months period in case of child rape has been provided. This is a matter of right to have a speedy investigation. Now, right to have a speedy investigation flows from section 173 1A of CRPC. I said you in the beginning, we need to read the rights of victim nowhere else, only in the CRPC. And CRPC, we are bound by CRPC. And if you see 309A, it provides that the inquiry at trial relates to an offense under especially 376 through 376D of IPC. As far as possible, they would be completed within a period of 2 months from the date of commencement of examination of witnesses. Now, this time frame has been capped, and this time frame is basically an assurance to the victims of crime about the speedy investigation, which is mandatory, which is important. And these offenses, especially 376A to 376D, as far as possible, to be presided over by a woman judge in the trial court. This is very, very important. And then we also see even the recording of the statement in such cases to be done by a woman police officer as far as possible at any place convenient to the victims of crime in the presence of social worker. I am saying these are very important protections provided to the victims of crime during the investigation of a sexual offense. This is very important. And also, you know that there is a ban on printing or publication of the trial proceeding in relation to an offense of rape and all those. The name of the victim, all the identity and those things. These things have become very important sort of guidelines. Initially, if you see in until couple of years, nobody used to bother about these things. But you can now very well aware these things can become very, very crucial for a police officer. You cannot simply treat them as mere formality. These are very important rights guaranteed to the victims of crime. Now, fourth right is the right and status during trial. No, during trial also, because matter doesn't end here. When the challan is presented to the court and the court proceedings start, let us understand how a victim is required to be treated. First of all, the victim or her or his legal representative shall have the right to be pleaded as a party in every criminal proceedings where the offense is punishable with 7 years of imprisonment or fine. So victim is a party. What I'm trying to tell you that initially the victim was not at all a party in real sense. Party status to the victims of crime. And then the voluntary organization can also be pleaded in the court proceedings, where suppose there is nobody to help, or suppose any voluntary organization who is willing to come forward to help the victim is also possible. Then, which is a very important right under section 24(8) of CRPC, the victim has right to be represented by an advocate of his choice. Otherwise, this was to be done by the prosecution until recently. Now, this right has been conferred on the victims of crime, where they can have their own advocate. This is very important, and this advocate can assist the prosecution. You can very well imagine what is the idea of this. Sometimes if the victim has this impression and the apprehension that the prosecution may not sort of come out very effectively in the court of law to take her case or his case effectively, then he or she can engage a lawyer of his or her own choice who can lead the evidence, who can present the entire case. However, this lawyer would be working under the guidance of the prosecution. Now, fifth right is very important. That is right to participate in a criminal trial. Now, what is this? I think if you have studied your law carefully, especially CRPC trial part, you can easily make out that the victim does not have much occasion to be there in the course of trial. The victim appears before a court only as a witness of crime, not as a victim of crime. I don't know if you are able to understand what I am saying. Appearing as victim before the court and appearing as witness before the court has got lots of difference. By far, the victim has been appearing before the court merely as a witness of crime. And the victim does not have any occasion to address the court like offender has. Offender has as many as 5 or 6 occasions during the trial where of accused independently, not through his or her lawyer, victim has to independently address the court. Victim can have, offender can have a say before the court. So participation of victim in the trial is a very, very serious question. But I have just mentioned that certain changes have been recently made. Certain, especially I think as a police officer, you also need to know there are important Supreme Court guidelines. Because in India as a country where the Supreme Court judgments are enough, they can serve as a law. Even though something is not provided in the law, but if there is a judgment of Supreme Court, that becomes binding on the court, on the police, on everyone. So certain things that you need to understand now, very important section which is generally not used is section 372 of CRPC, which provides a very important rights. Today we are talking about rights which have been conferred by the law to the victims of crime. This is the right that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation. So wherever victim is of the view that any acquittal has happened or lesser sentence has been imposed or inadequate compensation has been granted, victim can prefer independent appeal. Generally, appeal is by the state because victim is represented by the prosecution, that is the state. So suppose the state does not prefer an appeal, the victim can't help. But now, because of 372, but nobody guides the victim. Prosecution doesn't have time to tell the victim that you have got this right. The victim can again appeal independently. He is not required to request the state or the prosecution to file an appeal. The victim, and here the role of legal aid becomes very important. That's what I'm saying. Legal aid is also important for the victims of crime. But in India, we think a person who has suffered does not need any legal guidance. He has to claim the compensation. He has to pursue his case in the court. He has to go to the court, and all these occasions. And very important right. There are important Supreme Court judgments. I don't have time to really, but R.S. Nayak versus Union of India provides a very important right to the victim. Generally, what happens, suppose a charge sheet is filed by the police and the court is preparing a charge sheet. The challan is filed by the police and court is preparing the charge sheet. And at the time of cognizance or later, if the case results into discharge, the victim doesn't have any information. Victim is not personally present. So there is a case which was filed by the victim, and discharge proceedings are taking place when victim has no presence. Only prosecutor is there, but prosecutor sometimes he is a government servant. He may not be as passionate as a defense lawyer. आप समझ रहे हैं ना, जो डिफेंस लॉयर है उसकी जो इंटरेस्ट है बहुत ज्यादा होता है. Prosecutor to government servant, he may not have that kind of interest. So now R.S. Nayak provides that if the victim wants to be present at the time of charge proceedings, because sometimes the case is charged under a lesser offense, or discharge is taking place, victim can, raise his voice. But these are very important. There are many more such judgments where the victim can play some very, very important role. The sixth number right to participate in plea bargaining. Plea bargaining is very important under section 236, 265. Now 265E especially provides that while the awarding compensation to the victim at the time of disposal of case under plea bargaining, the victim is important, who can intervene in several ways to this matter. Now, similarly, the victim's role in compounding. We have a system of compounding the offenses. Now, compounding happens, case results into acquittal, victim doesn't know. Therefore, there is a duty now being cast upon the parties to have the victim suitably present as far as the compounding is concerned. Now, compensation, as you all know, I need not to elaborate. Now, we have 357A, which is the state compensation, and several, if the victim is rushed to even a private hospital, she or he has a right to be getting treatment in that hospital. The hospital cannot deny. If denied, then there can be a case against the hospital. All these rights provide the victims of crime a serious, position of entitlement where they can exercise several such rights. Now, generally what happens, we are talking in this country about the due process. Due process. So due process entitlements are equally available to the victims of crime. They are not simply meant to be given to the offender or to the accused alone. Due process entitlement, pre-trial rights, all these things are extremely important to the victims of crime. But overall, what I'm trying to say, that the victim in the present scenario has got a right to be treated with dignity and compassion. As I've said, the mandate of CRPC, the mandate of Constitution is that. That's why we have provided the right to access. The victim is one person for whom the access to justice is very important. And access to justice, the police has got the first responsibility to enable the access to justice for the victims of crime by allowing him to have his complaint registered. We have created a mechanism. If IO is not registering, you can go to SP. If SP is refusing, or you can go to the magistrate. And why the victim need to go is registration of, FIR has to be there after Lalita Kumari judgments, which you must have read. 3 very important judgments are there. So basically, and the important thing, right to information. As you know, right to information is available to all the citizens of the country under RTI. Are you aware now? Now, what does it mean for the victim? Initially, if suppose the FIR is registered, a victim wants to know what happens to his case, whether the offender, the accused has been arrested, whether he has got released on bail, what is the stage on which the investigation is. All these information, initially police thought they are not supposed to share all these info. But I think anything which is possible in Right to Information Act becomes your entitlement. So victim has every right to have this information, except for the privacy and other issues. So basically the protection, participation, assistance, access, legal aid, dignity, these are very important rights, which are very important. And that's why we are seeing these days that victim advocacy is becoming very, very important, because the victim needs a lot of protection and support from the police. Just a minute. Yes. Now, issue remains that the laws are there. I know we can discuss why these laws are not being enforced. As I have just said, that Supreme Court is coming out regularly with a lot of very important judgments, where, especially from the viewpoint of victim, there are several judgments now which are binding. And sometime you talk within your academy to find out what are those judgments which are important for the police officers to know, especially those dealing with FIR, investigation, bail, search and seizure, charge sheet, and even the prosecution. So these rights are now not only the rights on paper, these are some very practical rights. Because as I'm saying, when you give a space to the victims of crime, you are actually bringing a balance within the criminal justice system. And balancing the criminal justice system is the requirement of rule of law. It is the requirement of transparency. It is the requirement of Article 14, equality before law. If equality before law is not there, then justice cannot happen. And finally, in the scheme of justice, if you do not include the victim, the very idea of justice remains imbalanced, inefficient, and insufficient. So thank you here. I'm just pausing here. If you have any question, you can ask me. Yes. Anything आपके कुछ भी आपके माइंड में अगर कोई इशू आ रहा है तो आप पूछ सकते हैं.
Good morning, sir. This is Pratibha Sharma.
Yes, please.
Sir, what could be the more amendments in favor of the victim or the rights of the victim, sir? As we have already these provisions, but we are discussing that the victims are not getting the proper rights or the compensation in this present scenario.
Yes, so actually this process is already on, because unlike other countries, we do not have Victims of Crime Act. But I suppose laws are as you said, the 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 sentencing takes place, because at the time of sentencing, you never find the victim to be present. Only offender remains present. So if you are sort of deciding about the quantum of sentence or other things, any other, anybody else who has anything discussed? कोई भी आप, any issue?
I would like to ask one question, sir. You compensation which victims get after about the whatever the offenses, पर सर इसमें actually जो procedure रहती है, तो सर being DSP, how can we supervise it? What
देखिए आप
things should be kept in mind to monitor this?
हेलो, कैन यू हियर मी?
Yes, sir.
हाँ, देखिए उसमें इम्पॉर्टेंट ये है, एज ए पुलिस ऑफिसर आप पहले ये देखें कि कोई भी केस जो पुलिस स्टेशन में रजिस्टर होता है, जिसमें ऑब्वियसली किसी को कोई नुकसान हुआ है, उसमें एक compensation का प्रावधान होता है। इंटरिम कंपनसेशन 357 ए की प्रोवाइडेड है, उसमें आप एफआईआर सिंपली फॉरवर्ड कर सकते हैं डीएलएसए को, उसकी रिक्वेस्ट को इंडोर्स कर सकते हैं। एक बार विक्टिम की कंप्लेनेंट की रिक्वेस्ट, क्योंकि ट्रायल विल टेक लॉट ऑफ टाइम, तो उसमें थोड़ा टाइम लगता है, लेकिन मीनवाइल उसको जो जरूरी कंपनसेशन है वहां से मिल सकती है। एक दूसरा काम आप ये कर सकते हैं जो बहुत इंपॉर्टेंट है, वो ये है कि किसी वॉलंटरी ऑर्गेनाइजेशन को एसोसिएट कर सकते हैं जो थोड़े से विक्टिम की सर्विसेज, वेलफेयर और उसमें काम कर रहे हों। दिस कैन बी अ वेरी इंपॉर्टेंट ड्यूटीज द डीएसपीज कैन डू। You can empanel certain NGOs who are ready to provide assistance to the victims of crime by mobilizing the medical support, counseling, rehabilitation, temporary, homes or houses. ये बहुत इंपॉर्टेंट हो सकता है, तो आप कर सकते हैं। दिस इज व्हाट आई बिलीव। हाँ, ये सत्य हो जाएगी।
एक्चुअली जो छोटे डिस्ट्रिक्ट्स रहते हैं सर, वहाँ हम इतने एनजीओज इतने नहीं होते हैं जो विक्टिम्स की हेल्प के लिए इतने आगे आए। अगर हम चाह भी रहे हैं तो शायद हम नहीं पाते, तो वी हैव टू डील विद आवर स्टाफ व्हिच वी हैव। तो इन दैट कंडीशन व्हाट कैन वी डू?
चलो, अगर आपका क्वेश्चन नहीं है तो फिर Hello.
Sir, can you hear me? Can you hear me, sir?
Hello.
Can you hear me, sir? हाँ सर, आप मुझे सुनते हैं? यस सर। नहीं, ये जो अभी इन्होंने जो प्रश्न किया कि वो जो जी हाँ सर, तो मैं ये बोल रहा था कि इन्होंने जो प्रश्न किया कि अगर ग्रामीण क्षेत्र में है या छोटे शहरों में है, वहाँ पे एनजीओज उस तरह के नहीं है, तो उस संबंध में भी आप लोग ये प्रयास कर सकते हैं कि जो ग्राम रक्षा समितियां हैं, पंचायत की बॉडीज हैं और अन्य जो ऐसी संस्थाएं हैं जो कोई रिलीजियस ट्रस्ट हैं जो सेवा का काम कर रही हैं, तो उनसे अलाइन कर सकते हैं। खासतौर पर ग्राम रक्षा समिति को अभी हम बहुत ही लिमिटेड यूज लेते हैं उसका। तो ग्राम रक्षा समितियों में इस तरह के मेंबर्स को इंडक्ट करना जो उस क्षेत्र के रहवासी हैं और वहाँ पे सेवा का कार्य करना चाहते हैं। ऐसे हर जगह आजकल छोटे छोटे कस्बों में भी लोग ऐसे मिलते हैं जो ये करना चाहते हैं। तो उनको ग्राम रक्षा समितियों से अटैच करके उनकी भी मदद ली जा सकती है। तो ये एक मैं इन लोगों को बताना चाह रहा था सर कि ये जो है अ, अगर पॉसिबिलिटी हर जगह है, हम ये सोच के कि पॉसिबिलिटी नहीं है सिविल सोसाइटी को जोड़ने की और नहीं जोड़ें या प्रयास नहीं करें, तो फिर वो नहीं होगा। यही मेरा कहना था सर उसमें। रश्मि,
थैंक यू
आप
सर।
सुन पा? हाँ रश्मि, हेलो। अच्छा चलो, हाँ आप धन्यवाद दे दें। मैं मेरा कनेक्टिविटी थोड़ी खराब चल रही है, आप धन्यवाद दें सर को।
थैंक यू। वाजपेयी सर को मैं धन्यवाद देती हूँ, लेकिन सर एक आपसे पहले बताना चाहूंगी, चैट बॉक्स में अभिषेक चौधरी ने एक क्वेश्चन पोस्ट किया है सर। अगर आप परमिशन दे तो क्वेश्चन हमसे उनको अलाउ कर सकते हैं।
तेज चलाओ।
अभिषेक चौधरी।
Yes, ma'am. Sorry, ma'am. मैं एम्बुलेंस में हूँ अभी। मैम, आई हैव रिटन द क्वेश्चन, आई हैव टाइप्ड द क्वेश्चन। सर मेरा क्वेश्चन ये है सर। सर वो शायद लीव कर दिया मैम सर ने क्लास।
Let the meeting now. Sir has left the meeting now.
यस मैम, यस मैम। मैं सर से डिस्कस कर लूंगा मैम।
Join. We are at meeting now.
मैम यहाँ नेटवर्क इशू है, सर से डिस्कस।
Okay, Abhishek. हाँ।